Getting everything going for the YouTube live. I just need to. All right. Here we go, everybody. I am so excited everybody is here today. Getting ready to get started. Perfect. All right. Good afternoon, everybody, and welcome to yet another HIPAA Huddle. My name is Sarah Badaman. My co-host today is Cheryl Larson, who is the Director of Client Success here at HIPAA, and she is going to be helping us today with the HIPAA Huddle. So if you are new to the HIPAA Huddle, welcome. We are so glad you are here. So the HIPAA Huddle is questions that y'all have sent in to us for us to discuss as a group and for us to network. So don't be shy, speak up. We want to hear from you. The more interaction that we have through answering and working through these questions and scenarios, the more we all learn. As always, if you hear somebody speaking that you want to be introduced to, let us know. We are more than happy to help facilitate that introduction. All right. So as we're waiting for folks to continue to trickle on into today's huddle, I'm going to let y'all know just a little bit about HIPAA. So we are a software compliance platform that helps you manage your entire compliance process all in one application. We have a team of subject matter experts that are dedicated to you being successful in your compliance goals. So if you want more information about HIPAA or if you want a demo of the software, please contact Jane. Her information is right down there at the bottom of the slide. It's just jane@hipatrek.com, or you can give her a call at 314-272-2600. All right, so we have an exciting announcement that we're going to continue to announce. In April, we launched our HIPAA community. It is live, so be sure to check it out. It's a way to continue these conversations offline. The HIPAA Huddle is once a month, but the HIPAA community is all the time. So feel free to check it out, post your questions, and interact with one another on the community as well. All right, getting started. This call is being recorded. Everybody will receive a copy of the recording at the end of today's huddle. Your mics, well, they are muted now, but feel free to turn your mics on when you want to talk. You may also choose to turn your video on so we can see your lovely face as you talk to us. Or if you want to keep it off, that's up to you. And just remember that the more you participate, the more we all gain. I do want to thank our normal or regular contributors. So we have Erin McLean, Sharon Kamowitz, Dina Castricone, and Michael Herrick, who regularly contribute to the HIPAA Huddle, as well as part of Shaw. So part of and Michael focus a lot on security questions, whereas Sharon, Dina, and Erin help us with privacy issues. So here we go into the questions. All right, I was reading a story about a hospital that would put a star sticker on a person's badge if they had received the COVID vaccine. They did this so management could identify if that person was required to wear a mask or not. My question is, by having a sticker that anyone can see, are they forcing people to disclose their own PHI? All right, guys, what do y'all think about this question? Okay, I can get started. So in my opinion, vaccination status is not disclosing PHI. So I don't see this as a violation of HIPAA. So does anybody else want to comment on this, or how are y'all identifying that your employees have had the vaccine?
Parthiv, I agree with you. It's not an issue of disclosing PHIs.
Perfect. It looks like in the chat, everybody is saying the same thing,
Yeah.
that they agree. So perfect. So we'll move on to the next question. All right. We have a written policy that states we retain patient medical records for at least 10 years, but we often have records that are much older stored in our EHR. There are times that patients call us looking for an operative note from 1992. And if we have it, we usually do have it saved electronically in our EHR. We will release it to the patient. But when we receive a request for any and all records, we only release 10 years because that is our policy, or what our policy says we are required to retain. Is it correct to only release 10 years worth, even though we have access to 20 years of records? So this, in my opinion, is a trickier type of question. I'm going to look really quickly to see if Erin is on the call, because I know that her and I had talked about this previously. Erin, you are here.
I'm
Erin.
here.
Hello. Can you give
Hi.
us some insights here?
Maybe.
Maybe.
You know, I find it curious that you would keep records when your policies say that you only retain them for 10 years. That's one thing I'm going to note. And so it sounds like you're violating your own policy by retaining records that you're saying you're not going to in your policies. So that probably needs to be reviewed. If you have the information and it fits within the designated record set and you keep them electronically, I think we're not necessarily looking at HIPAA, although we can say HIPAA permits us to disclose that information, right, pursuant to an authorization or patient access. So it really depends on who's requesting them, what applies. Yet at the same time, when we're looking at the Cures Act and information blocking, if we're looking at things for treatment purposes, especially, I would start thinking about, are you not providing information that fits, under the open notes requirements when you should be, if that's what's requested? And if you have it and you're not releasing it, there could be questions asked and a review done. We don't know how some of this is going to be reviewed by the ONC eventually, but I would be very concerned about what you're saying here, because you're not following your own policy and you're restricting, sort of arbitrarily restricting what you provide to somebody in relation to HIPAA. So I don't really see that this falls under HIPAA. I think it's just a weird application of a policy, Sarah.
Well, I think it gets worse as Parthiv here, because you're opening up yourself. If there's a breach, you are going to give access to a lot more records than you should. So from my perspective, do not keep anything you don't need beyond what the federal government or state requirements are and what your policies are. Because if you do that, you're just opening yourself up, which I think could be absolutely lethal. And I've seen instances where people have just hoarded records, stored records, and then when the breach occurs, it's open season. So I would definitely look at this very, very seriously. If and be sure that you maintain just the records you need. Otherwise, I think you're opening up yourself up.
And I agree. I think there's also the risk of litigation. I think Erin summarized everything related to HIPAA and the Cures Act excellently. But I think I'd also be concerned, because if a plaintiff's attorney finds out that you're holding records that you haven't turned over, I think that's a risk.
That's interesting too, when we talk about litigation, right, on everything here. So yeah, I think you definitely need to at least revise your policy, right? Revise your policy, and then start purging records that you don't need. So it looks like.
And you know what's even what's fascinating for me is when it comes to PEDS, right? it could be, it varies all over the place, correct? So I mean, 10 years, is that even an accurate policy, right?
Right. Well, yeah, Angel Shreves put an interesting suggestion. So she says that they don't respond to records that say any and all or entire records. They ask that they're specific to the time frame, right? So, right. So what does Sharon and Aaron think about that, right? So if they receive a records request that says any and all, and they respond back to that request saying, well, how many records do you need? So then we have another question that says, is that even legal for them to not respond to the question?
Right. And it says our agency. So my question is if they're a HIPAA covered entity. So if you're not a HIPAA covered entity, then, there's more ability for you to respond in such ways as this. If you're a HIPAA covered entity and someone's requesting access or requesting records in a manner that's compliant with HIPAA, this policy does not appear to be compliant. And if someone wants access to their entire designated record set or the entire, depending on what law we're looking at, you have to provide that. And minimum necessary is not something that applies to what it is that I perceive as being said here. Minimum necessary applies to payment and operations, disclosures and uses that are the exceptions to the authorization rule under HIPAA. So when we're looking at minimum necessary, we're looking at our disclosures of payment and operations. And so I think there's a weird application here that I don't understand. And I would be concerned about what's being said here.
Yeah, but sorry, I mean, and maybe I'm mistaken here, is that why would somebody, if you're not a HIPAA covered entity or a business associate, why would medical records be somewhere else? Because if you're storing data, transmitting data, processing data, blah, 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 right? It applies. So if somebody is storing, then that itself is a big issue, right? Maybe I'm just a little bit confused, is nobody should be having this data unless you follow the guidelines.
So there's an indication from Angel here that there's a 42 CFR Part 2 component to this. What we talk about with 42 CFR Part 2 are the requirements to keep information confidential, and it's more restrictive than HIPAA. And what we look at are the consent forms that are signed by the patient to determine what can be used and disclosed, at least before the CARES Act rules come out. So I still don't understand what is going on here because it doesn't seem to fit under HIPAA or Part 2. So it seems like you need somebody who understands both laws and applies the appropriate standards to the records you're talking about.
Awesome. So does anybody else have any input on this question?
Could I ask Aaron a question? Aaron, I would ask you to speak to it from the other side. What if somebody came to you and said, I'm a patient at this organization and I've requested any of and all records and they told me they don't do that? Would you be interested in taking that person on as a client and representing their interests?
The person who's not getting access? I've done that before, but I generally try to help the providers get get themselves straight. I don't act as a plaintiff's advocate. Generally, I act as a provider advocate. And if I hear about something being done, I would rather get with the providers and say,
yeah,
let's get everything
But
straight.
if you did, wouldn't you kind of say that patient maybe has a case?
Yeah, well, I would say that patient definitely could find a plaintiff's attorney who, and the plaintiff's bar is very interested in HIPAA violations right now, everyone. And also Cures Act violations. I actually had a client come to me. They're now being investigated by the ONC under the Cures Act as a result of refusal on patient access requests. So I'm telling you right now, it's already happening. So we've got to get it straight, right? I mean, we don't want to inappropriately disclose under Part 2. So I understand that. We definitely need to work with our consents. Yet we have to make sure we understand what all these terms mean and how they work together. So Michael, although I have done that, you know, for friends in the past, like sent letters saying, this isn't okay, you need to do this. I know, believe me. I would rather work with the provider.
And I was just going to add on, and I see Angel posted this in the chat, where I was going to go with this is, if somebody asks for any and all records, you certainly can go back and say, do you really mean it? Can we narrow this down? But if they want any and all records, they want any and all records. But sometimes people just say that and they don't really need it. So yes, they can come, you can ask them, is that really what you mean?
Right. And you can't try to dissuade them if that is what they really want. You cannot try to dissuade them or try to make them believe that they need something that they're, I mean, that sort of interaction would also not be looked on well. You really have to work with them on what it is they actually need. And if you're going to do that and give them something other than what they requested in writing, then make sure you document it and make sure that there is like clear documentation that they clarified exactly what they wanted. Because if you don't do that and they come back and they say, well, no, I really wanted all the access, but they, you know, access to all the records, but they told me that this is really what I want, and that's not really what I wanted, you could still get yourself into a place you don't want to be in. So again, you know, I don't know where you are as far as, you know, your ability to provide things electronically. You know, the whole point of where we're moving to in the future with interoperability and, you know, open notes and all the things that are allowing things to be exchanged electronically and accessed electronically is to make it so it's less onerous to provide access to the information that you do have. So it can't be the reason for your restricting or trying to request that they want less can't be because you don't want to have to go back and give them all the records that you have, is what I'm trying to say. And sorry, I took a long time to do that.
Yeah. So essentially, you need to make sure that you're doing what your policy states and that your policies align with both the information blocking, so cures, 42 CFR Part 2, HIPAA, and any other state or federal regulation that you have to comply with.
Right.
And make sure, yeah. So align all of your policies to the regulations and then make sure you're following the policies and you'll be good.
And let me just add one more thing here is in this scenario, trust and identity becomes a big issue in the sense from a provider perspective to ensure that person who's claiming who he or she is, and that's where information is going to when you do electronically. So
awesome. Thank you guys. All right. So here's another policies question. And I know Pardiv and Michael will have a lot to say on this one. So our policies say we will back up all PHI on a workstation before we wipe to use somewhere else. If an employee like a CFO leaves, do I need to filter through all his documents, desktop, and downloads to check for any PHI? We have a cloud EHR and all of our financial PHI is stored on a local server. He might have some reports that contain PHI. Does this policy refer to all PHI or only PHI that is part of the designated record set? So to me, this sounds like it's multiple places, right? So one, you have a policy that takes care of the device and media controls for how you're going to reuse a device. So that's one question. And then it falls into what the minimum necessary and designated. Well, yeah. So I'll let Pardiv and Michael take over from the best practices for device and media reuse.
So
first, I just want to clarify the intent, what they're trying to achieve. We're going to back up all PHI on a workstation before we wipe it. Okay. I mean, I would just assume, yes, there's PHI on that workstation. PHI is like an oil slick. It gets everywhere. And anytime I see somebody saying, "Oh, but that's a finance computer, we're not going to encrypt it because it doesn't have PHI on it," I'm like, it has PHI on it. It's got PHI on it. You should be protecting it. However, what they're talking about here is they're saying, we're going to make sure that we back up the PHI. Just because it's PHI doesn't necessarily mean it even has to be backed up. I was just working with somebody and they have some kind of workflow where they put PHI into a system so that they can print something out. And then once it's printed, it's done. And whether it sits in the system or not is totally irrelevant. The PHI lives in the EHR and their systems. This is just this little utility system on this one little workstation that is for this one little workflow. And yes, it has PHI on it, but that doesn't mean it needs to be backed up. Somebody might download a report of PHI from the EHR and they use it for making some kind of report or checking something. That doesn't necessarily mean it has to be backed up. So, if the CFO has PHI on their workstation, the question I would ask is, yes, it's PHI downloads, and I'll work on for this next week, and then the data is disposable. So that policy seems very broad to me. I don't think you have to back up PHI just because it's PHI. You have to back up PHI if this is your designated record set. What would happen if you lost that data? Losing the PHI on that CFO's hard drive may not affect the company at all. They've got that PHI someplace else. So if that's the situation, that's what I would dig into.
So I have a little bit of a different view on this. I agree with what you're saying. My question is, why would I even try and filter through something of somebody who's left the company or the organization? For me, it's very simple. Once you leave, that workstation needs to be wipe it clean using DoD protocols, absolutely clean it out, because you don't know what's on that laptop, what's on the system, and if you've been backing up on a regular basis your PHI or whatever data you think is relevant from your perspective, I think there's no need to go through this, because you could be setting up yourself for something even worse than you might expect. That's one thing from my perspective. Second thing is, if the right provisioning and deprovisioning system in place, then this question will be moot, in the sense, I'm saying, because you cut off access and then you can wipe it out clean. I'm saying, so I would not filter it, period. Doesn't matter, because if you have your act together, I don't think you need to. That's my take. Again, not saying it's right or wrong, but that's the way I look at it. So
Right. I think too, like a lot of stuff that a CFO is going to have on their desktop or workstation to begin with is going to be stuff that's replicated data anyway. They're going to have pulled those reports out of somewhere, right, to digest and create other stuff, right? They're going to have pulled it out of their accounting software. They're going to have pulled it out of the EMR. They're going to have pulled it out of something, right? So that data is already backed up somewhere else, and we don't want to create multiple versions of stuff either, because then that becomes a data governance nightmare.
And
right?
if that data in the form that the CFO is using it, if it needs to be backed up, it should have been being backed up the whole time the CFO was still employed, right? It should have already been part. If it needs to be backed up, it should have been part of a backup strategy already. So just when somebody leaves, I don't see that as a trigger for backing up. That's clearly a trigger for wipe machine and make sure that it's clean before you reassign it. But I don't see that as a trigger point for backing up.
You should not be backing up the data, period, from my perspective, because either you've taken care of it or you've not. Once the person leaves, from my perspective, as I said earlier, wipe it clean before you do anything with it, because you have no idea what resides on it. And again, depends on how good your policies and procedures are in keeping things the way they should be. But anyhow.
Right, because that kind of gets into part of like, how are they backing up or storing their information, right? Is it on an intranet or a shared drive of sorts? Where is it stored? Is it stored on a server? And so there's really not much locally anyway. And yeah, this gets into a lot of what ifs. So does anybody else have anything to add here? Alrighty. All right. So our nurses have a logbook for whenever someone passes away. They keep it at the nurse's station, and the mortician signs it when he takes the body away. It has the patient's name and date of passing in the book. The morgue will then post online and in the newspaper, letting the public know about the death. I thought we needed to lock up the book because it is PHI. The nurses think it's not necessary because it is public information. So what do y'all think?
I think you lock it up.
You think you lock it up?
Why would you not lock it up, right?
Right. I mean, because I'm thinking like what the morgue does or the more like the funeral home does is separate. They're not a covered entity, but you as the hospital are a covered entity and are required to protect this information. So my opinion is that it needs to be locked up. I wonder how other folks are handling this.
I would agree. I mean, I'm assuming the morgue is doing it with the patient's permission or the family's permission, and that they're not just posting it as a regular course, because I think that could get them into trouble just for violating depending on state law. But so that would be my first question: is why is the morgue just posting these online?
Yeah, it's scary because you know what? I might not want an obituary in the newspaper once I pass away. You know what I'm saying?
Right. I'm with you, part of there.
It might become public data at some point, but it seems like as long as it's inside that building under a covered entity, it's PHI. It has to cross a threshold somehow before it becomes public info, wouldn't you think?
Yeah,
Right.
Michael, that's very true. I'd like to take a step back and talk about a book. I would look at this practice.
Seriously.
I mean, we need to have individual document for every person that goes into their record and not a log book. This appears to me to be an outdated practice, and the individuals that are handling the book that are not part of the provider shouldn't be seeing it unless they have reason to all the other individuals that are in this book. I don't see that there's this sort of there would be an allowance for this isn't sort of like the minimum necessary for you to document individuals and their passing and the mortuaries taking them, and it just seems like a not good practice. So I know what you're asking of, like, should we lock the book up? What I'm saying is you should get rid of the book and change the practice.
I would agree, Erin. And it looks like Deborah May also made that comment. So she said, we get them to sign a release of body form that is signed by the family member and the funeral home. It is then placed in the record.
Right, Deborah, that's a good practice.
That seems like a really solid practice. So instead of a book, you just have forms, right? So, because I know that this came from a critical access hospital. So it's not a book that's being utilized frequently anyway. Because you're not a super large health system, you're a tiny critical access hospital. So I like Deborah's practice of creating a form and then just making it part of the EMR. Then you don't have to worry about locking it up.
Exactly.
All right, so does anybody else have anything to add on this slide? All right. Okay, so do we have one more chat before we get it? Okay, so if a patient changes primary doctors, can a program contact the new primary even if the first contact with the program was 2 years ago? This came from a substance use disorder clinic or not clinic, facility. So by program, they're referring to a Part 2 program. And the primary doctor is obviously the PCP. So
I think we need more information to answer this question, Sarah. If it is a Part 2 program, then we really have to look at exactly what the patient consented to. at the time that the individual was at the program. And if there was a consent that said any primary care physician or all of my primary care physicians, that would be one thing. If there was a specific consent to one physician, that would be something else. So it really, and I don't understand contact the new primary care. I don't know why you would contact the primary care unless you were asked to do so and there was a consent. So again, we really need more information to answer the question.
Yeah, I'm looking to see if they are on.
And I'm trying to understand what if the first contact with the program was 2 years ago.
Well,
By whom?
I don't know if the person who asked this question is on the call, if maybe you can provide some clarification here. Otherwise, we'll move on because it is difficult. But I do like to reiterate what Erin was saying, though, is as a Part 2 program, you need patient consent to contact. So regardless of the time period.
For treatment, payment,
For treatment.
and operations right now. Mm-hmm.
Exactly.
And even when we get the new rules under the CARES Act, it still is going to be clear that we need a consent that specifically designates, what it is we can do. So that consent is going to continue to be very important in our Part 2 programs and really should be our focus.
Right. Okay. So, oopsie. Moving on. Okay. We get one of these questions every few months. So is it fine to include PHI in emails strictly for internal circulation? Emailing PHI is what I would call.
That's no.
I'm sorry?
Definitely no coffin.
Yes. And it really should be an organization by organization determination. It depends on how your email is set up. What is your policy for retaining that PHI in emails? Is your email encrypted? Do you have a business associate agreement with the email provider? There's so much to consider that it's so difficult to answer these kind of broad strokes questions. But I know
and Sarah, I love the word fine. What does that mean? In under HIPAA, we talk about compliant, not compliant, secure, unsecure. So
I think it means, will I be fined?
Right, will I be fined? Well, it just depends. Like, you could be fined even if you're paying millions of dollars, in response to an investigation. Like, you probably will be fined. Like, you won't die. But, compliance, another question.
I mean, to make it simple, it's very bad cybersecurity hygiene if you're doing this. First of all, without encryption, and you just can't willingly just send emails out with as PHI because who knows where that's going to end up. And we have no idea what safeguards are in place to see that it doesn't leave your domain and goes outside somewhere. So I think it's, from my perspective, it's a very poor practice to do this.
I mean, I'm just going to jump in and just to play devil's advocate. I agree with everything, but there are situations in which PHI needs to be emailed. So again, as Sarah said, it depends on your organization and what safeguards are in place. I've certainly, when I was working in a company, received emails with PHI, for example, as part of a breach investigation. We had proper security measures in place that the people could email me the PHI. I think the other thing is, looking at keeping in mind, obviously, minimum necessary, who needs that information? And if there's a way to avoid the email, for example, if you can link to an internal system instead where the PHI is held rather than sending it through the email, you're always better. But yes, there are situations if the proper security measures are in place and you're sending it to the right person and you've thought about minimum necessary requirements that you can email PHI. But it's one of those, it depends situations.
Right. And I think to your point, you need to be sure you have the appropriate measures in place, right? Of where this travels, whether it can leave the premise, it goes out, etc. And then, you can only do so much. But again, I think whatever the policies are, I would definitely look at this and see if there are any of the better ways of doing it. If none, then you're right. You don't have a choice.
I'd also say there are definitely worse ways to share PHI: fax machines, paper, books with people's names in it that are not being locked up. There's worse ways. The only way to answer this is a risk assessment. You have to look at everything that's going on at the organization. You have to look at policies. You have to look at security controls. It can be done. It can be done well, and it can be a good fit for organizations that go at it. But is it fine? It's not fine. It needs to be looked at carefully, and that's what a risk assessment is for. That's what I would say.
Right. I mean, it's really difficult to say black and white whether or not you can or cannot do this, right? Because there's so many different considerations that have to be, like you were talking about, Michael, the security risk analysis is really the first place to start. And before adopting a software like this, you really should do a risk assessment, at least around the adoption of the new software, right? I know Michael has done those, Pardev has done those. I know for a fact Aaron has helped with the compliance aspect of those. So, I mean, there's a lot of folks that can help around how to go about implementing all of this, but you really need to evaluate everything inside of your organization and even know, why is this the policy, right? So, because I know, like, at the last practice I was an administrator at before I left to start HIPAA Track, like, we had one provider that was just dead set on emailing PHI because it was the easiest way for him to get his information from hospital rounds to the biller at the practice, right? And so he continuously did this despite our best efforts, right? And so when we learned that this is what he was going to do, we set up a third-party application that allowed him to securely email that directly to the biller, because sometimes it's just ease of use for one of your healthcare providers or one of your like senior leaderships that are they're so busy, they need an easy way to get things done. And so then, as the person responsible for the security and the compliance in your organization, you have to make sure that you find a secure way of doing it, right? Because the one thing we don't want to do is become the department of no and O. We want to be the department of K and OW, like of knowledge, right? So just saying, no, this isn't a good practice, even though I would agree with everybody that this it's not good cybersecurity hygiene, like Pardev was saying, we need to consider everything to make sure that we have the proper safeguards in place if this is something we really need to do to make somebody's life easier.
Let's be clear, OCR has explicitly said that this is not forbidden. They have explicitly said that the security rule does not forbid this, and it doesn't even forbid unencrypted email. But it says, if you apply all the appropriate security controls. So you got a lot of work ahead of you. You can't just take that as a carte blanche to just email anything you want from your Hotmail account. That's not what they're saying either. Right. They're saying the security rule doesn't prohibit it, but you have to apply proper controls.
And Michael, I agree with you.
Further, oh, go ahead, Pardev. I apologize.
Sorry, it's not prohibited, but guess what? Because of your complacency, if a breach happens, HHS or OCR, they're going to come and say, hey, no problem. We'll let you go because you know what? You did the right thing. You're still accountable. So whatever step we take, that's always hanging on our heads, right? So I'll be honest and candid about this. HHS at times is not very clear, even when it tells you what to do. And we can spend hours on this, right? But I think we're talking the same thing. I think in the end, right, put everything in place you can and be sure, and then proceed with the appropriate policies and procedures in place. You know what I'm saying?
Right. But I think that we also need to be very careful that even though the OCR does not explicitly prohibit this, when you look at CMS regulations, you cannot email patient orders. So if you're using this for patient orders under CMS, you are not allowed to do that. So we have to be very careful that we're looking at everything and what the purpose of this is. Interesting.
And you're talking about the rules of participation, right, Sarah? That's what we're talking about.
Correct. Yeah. Correct. Thank you, Aaron, for clarifying my thought.
No worries. Just, designating where people can find this information.
Yeah. Aaron speaks fluent Sarah. All right. Awesome.
Yeah. So we'll contact you, Aaron.
Yeah. Yeah. Pardev also speaks fluent Sarah, which is good. All right. So this is the question of the day. I'm glad we still have a good chunk of time. This is our last question for today, and I know it's going to take some time to walk through. For risk of harm, so this is underneath the Cures Act information blocking, talking about the risk of harm exception. What is the best process for providers to communicate to HIM for denying a request for information? Providers want HIM to come to them with requests. However, how are others dealing with this? So this was a very long question that Bethany from our team shortened up. So essentially it's an FQHC, and the providers are telling the HIM department for every single request, they want the HIM department to go to the provider to get permission to release the record, which is obviously not a practice that can continue to happen. So,
Hey, Sarah,
mhm.
would you be willing to, I just posted a link in here, and that's the link to the exceptions page. It might be helpful for us to have that exceptions page in front of us if you're willing to do that. And if not, everyone can go there
Absolutely.
because that's where it is.
Yep, I'm sorry, I didn't mean to do this. Hold on. I'm gonna have to stop share because I obviously don't know what I'm doing. Here we go. Let me, oh my goodness. All right, so while I'm pulling this up, because I'm not going to be able to have open the deck anymore. Okay, here we go. Pulling it up, Erin, sorry. There we go. Here's the exceptions page. And they're talking about this preventing harm exception, which is right here, and I'm going to make it bigger. Erin,
Right.
you're on
And
mute.
before we get into the exception, the general rule is that information blocking is a practice by a health IT developer, a certified health IT, a health information network, a health information exchange, or a healthcare provider that, except as required by law or specified by the Secretary of Health and Human Services as a reasonable and necessary activity, so that's what we'd be talking about here, is likely to interfere with access, exchange, or use of electronic health information. So that's where we're starting from. And then we move into these exceptions that allow you to, either deny access or delay access to this information for certain reasons. And this one is, I think, Sarah, the one they're talking about, which is the preventing harm exception, right?
Correct.
Okay. So, I mean, this is a pretty good summary here. I like these summaries, and you can go to healthit.gov to get them. So I think that's the best place for you to start. So remind us, Sarah, what the issue is.
Okay, so they were asking more on process, right? So essentially what's going on is the providers are wanting HIM to go to the providers before they release a record, right? So because of risk of harm. So HIM had told the senior leadership, who then that here is what information blocking is, here are the exceptions, and HIM was trying to get the providers to make a note inside of the EMR when they want to utilize the risk of harm exception, right? So this patient is suicidal, this test result may result in them taking their own life or harming somebody else, do not release this information, right? And instead of the providers wanting to make that note in the EMR, the providers then responded to HIM that they needed to get permission for every single release from the provider. So I think HIM knows what this means, what the risk of harm exception is. They just don't know how to actually implement it, right? Like, I think that's the issue. So they're looking for the best practice. Can you guys hear me?
Yep.
Everybody's just stumped.
Yep.
Yeah, I was like, okay, I got real quiet. So it's more of what is the best practice to implement when there is a risk of harm exception that is here, like this is the risk of harm exception, right? So how do they best implement it? So it'd be interesting to kind of hear what is everybody else doing, right? When we're talking through like this here, right? So what is everybody doing?
I'm sorry, Sarah, I got disconnected, so I didn't hear a lot of that.
No worries. It's so how are other like folks like hospitals and clinics actually creating their risk of harm exception policy? Like what's the process of alerting medical records or HIM when there is a concern of risk of harm? Because I think of all the exceptions, this is one that does require multiple departments and multiple people to be able to communicate and work together in order for it to be implemented properly.
So, Sarah, I think it's a good place to start, unless you've already said this. These exceptions are not going to be used often. So what I think first everybody needs to remember.
Oh, I think Aaron's having internet issues. Okay, so Aaron is right. These are not going to be utilized often. I wish that she hadn't lost connection here. So, but it is still important for us to have a policy and a process in place in order to understand how and when to use these. So I would be really interested to hear. So here we have a couple folks here. So somebody's saying notation should be placed in the record so that HIM is aware of the risk. Louis, I agree with you. I think that that is the best way of doing things versus having medical records get approval for every single request, especially since, like Aaron said, this is going to be such a rare situation. Lois is saying we ask a provider to sign a release if the chart has the information in it that is concerning or has, yeah. Okay. And then Sandra says it appears that there should be a system related to process, which will have an alert, which would be accessible to HIM. And then somebody says, what would be Donna asked, what would be an example of this? Donna, are you asking? Okay. Yeah, Michael made the point that I don't think anyone is sure how to handle this yet. And
I think your point, Sarah, I mean, this is really new stuff. It's really going, this is one of the biggest friction points I've seen recently between what's really happening in providers' offices and what the regulation is requiring. You know, I'm seeing a lot of friction where doctors are saying, I don't want to do this. I don't like this idea. I'm seeing a lot of pushback on this. I don't know how this is going to shake out. I wonder if you have any thoughts at that level. This seems like a unique situation that's new, and we're seeing a lot of resistance.
Right. Well, I mean, I think that was too, like, it is a unique situation, right? It's not going to be often that risk of harm is going to be enacted. It's going to be something that is rare. All of the exceptions in the information blocking exceptions are going to be uncommon scenarios, right? Most of the time, we're going to have to release the information. And under risk of harm, particularly, it's almost like, how do we fix healthcare is how do we fix this problem, right? Because when I think about the whole healthcare operations, we have essentially a three-legged stool of healthcare operations. We have the finance, we have the clinical, and then we have the legal and compliance. And historically, these legs like being separated. We don't like to talk in and with each other. If HIM goes and talks to a provider, from my experience, when I was in the HIM department, I try to chase down a doctor. The first thing they're going to do is yell at me and say, if you're here to tell me you're going to suspend my privileges, and so this issue here is almost, how do we fix healthcare in and of itself? Because risk of harm is going to require HIM and providers to work together in a way that they've never worked together before. You're going to have to create a policy that states this is what, when a provider says not to release the information, there needs to be a way to notate it in the chart. Then HIM needs to adhere to that notation. If they have a question, then they go to the provider before releasing the information. And so it's going to create this type of communication between HIM and providers that has not existed previously. And it's going to take a lot of change in some hospitals and in some FQHCs and in some clinics even for that to kind of happen and be resolved, right? I think in this case, small clinics have a leg up because they're owned by the providers, and the providers pretty much say everything anyway. And so if the medical records clerk has a question for the provider, it's easy peasy for them to get that access. But I think that this is going to be something where, like never before, we're going to have to start working together.
And Sarah,
my soapbox.
Can you hear me? This is Erin. I got on
Hi, Erin,
cell
welcome
service.
back.
Hi. So, I mean, I would start with, you know, the healthit.gov pieces. I would say, you know, I would even have a form. The actor, who is the actor? Who's the one saying that they think there's going to be harm? What's the reasonable belief, right? That the practice will substantially reduce a risk of harm. Like, what do you think is going to be the harm? And why do you think this specific practice is going to reduce that specific harm, right? And why is it the least broad way that you can reduce this harm or make this harm not happen, this specific harm? And also satisfying what is the risk? You know, what is, like we talked about, the type of harm, and then how are you going to implement it, either on a one-time basis or on an ongoing. I mean, you have to figure out how you're going to implement this restriction. And then, you know, you have to say, like, how is this, you know, outweighing the patient's rights? So you really have to get specific. And I would come up with a way that you can evaluate whether this is reasonable and necessary, you know, based upon the rule, because I think there are some perceptions that people are protecting individuals against themselves when really it's not lawful for them to do so.
Right.
So, and that's going to be especially true here.
Right. And again, I think that's just going to go to creating your policy, training your providers, and training your HIM department on exactly how these records requests will be facilitating.
Right. And train everybody that this is going to be rare. What I see from what you put up here is that they want this sort of like blanket policy or something where it's a regular thing. The providers need to just be trained on, this is not going to be a regular thing. And we're also not going to restrict, you know, labs from being posted on the EMR until you can review them with the patient. It's just not allowed anymore.
Right.
I think you're right, Erin. I mean, obviously they're trying to say this has got to be rare, and every question that comes up, that's what people don't like. People are saying, I don't want it to be rare. I want to do this kind of all the time. They've been used for years to, this is their standard procedures. They review all of them before they go out.
Right.
And now we're trying to throttle that back to a rare, exceptional situation. All of these questions are, how do I make this a routine thing?
Right.
That's the friction I'm seeing.
Right. And there's a statement here, sensitive template or sensitive information. Really, that doesn't fit within the construct of what we're looking at anymore. I mean, you may think it's sensitive and somebody else may not. So we're not talking about sensitive information. PHI is PHI. And if there are permitted disclosures for treatment purposes or for access purposes, you don't get to decide that it's sensitive anymore. You get to decide whether there's a risk of harm and go through this evaluation, but your perception of sensitivity or a provider's perception of sensitivity is really going to be irrelevant in moving into the future. It's not up to your decision-making power anymore on that.
Right. All right. So in the last 5 minutes, we have a question that is unrelated to this question here. So we'll move off of the slide. Lois is asking, this is out of context for this conversation, but I wondered, is it legal for a police officer to tell HIM that we cannot tell the patient that they requested their records? I love this because patients are allowed to ask for an accounting of their disclosures. To my knowledge, law enforcement can ask for patient records under certain circumstances, but that still needs to be documented, and patients are allowed to know that that was requested and was disclosed.
There would have to be a special court order denying that, right? I mean,
right. I've never come across this question.
Right.
I mean, I'm assuming there has to be a warrant, but not even just a warrant. There would have to be a warrant and a GAD rule. The lawyers can tell us.
Yeah.
Yeah, Sharon, Aaron.
Yeah, I mean, it's just an overstepping by the police.
Never take legal
They don't
advice
have
from the
to disclose
police.
what's going on in their investigation, but they can't tell you to violate HIPAA in order for them to keep that quiet during their investigation. So, yeah.
Right.
Wow. They could
They can
ask you
tell
not to
you.
volunteer that information, I guess, as a favor. But if the patient asks for it, it's got to be logged and disclosed, right?
I know, and there has to be specific reasons for the police even to ask, right? So is it to locate a fugitive of the law or a suspect, you know? And then, like, what do the police think you're going to do? Pick up the phone and call the patient? Run, the police are on their way.
Well, and the question is how did the police get the records? I mean, really one of the key laws regarding HIPAA, or I shouldn't say laws, one of the key Supreme Court decisions out of Vermont regarding HIPAA recognize the fact that there are a lot of times when police ask for information that they don't have a right to. And we have to be very careful about that. And I know sometimes we want to help the police, but that's not our job.
Exactly. I know that this is.
I had a client one time, a patient stole a car from the parking lot and the police came by and said, well, could you tell us where this guy lives? I don't know what you guys would think of this. The clinic did give that information out, and they went and the car was parked outside that patient's house, and they recovered the car and somebody went to jail. I don't know if that was legal or not.
Well, I always advise for people to talk to their attorney.
Yeah.
Like that. So that is the best piece of advice, is to have a HIPAA attorney like Sharon, like Aaron, that can help you answer those types of questions that get into the nitty gritty of all of that stuff. So, all right. We are out of time. As always, thank y'all so much. This was lovely. If you would like an introduction to anybody that you heard speaking today, please let us know. We are more than happy to facilitate these introductions. Thank you again to Pardiv, Michael, Aaron, and Sharon. We love you guys so much and truly appreciate all of the valuable guidance you provide to all of our huddlers on these monthly calls. Remember that effective and efficient compliance management is not a myth, nor should it be a burden. Automate and simplify your compliance management with HIPAA Trek. All right, happy HIPAA trekking, y'all. Have a lovely rest of your week.
Thank you. I'm going to go to bed with HIM on my mind tonight, so thank you.
Thanks, Pardiv.